everyone. We would like to welcome you to this training on gig worker protections. Primarily, we're going to be talking about protections for app-based workers, but Seattle has more protections than just for app-based workers. We also have independent contractor protections for everyone, including app-based workers, but also for people who work in other industries. So in this training, we are going to skip the quick activity because this is not the live training, but we're going to talk about the Office of Labor Standards 2025 settlement with UberEats. We're going to talk about the protections that are available for independent contractors working in the city, regardless of their industry, and then specific protections for app-based workers. We'll finish by talking about what you can do if something goes wrong or if you have any questions about your rights or your obligations under these laws. Before we get into the training, we just want everyone to know that the Office of Labor Standards does not ask about immigration status or collect immigration information so that we can protect it from disclosure. So everybody is protected no matter their immigration status. It doesn't matter what your status is. You can file a complaint. You can still get assistance from the office. We also offer free language interpretation and translation if you request it. Our team will speak to you in your home language, or they'll use an interpreter to help us speak to each other. And we have a lot of written resources on our website in more than 30 languages. So if you're looking for some sort of resource, please go to our website and see if we have it in that particular language. If you don't, you can reach out to us so that we can get it translated. Before we get into the details about the UberEats settlements and then the protections that are available for independent contractors and app-based workers, I want to make it really clear that Seattle has its own set of laws about app-based workers, and those are different than Washington State's laws. Washington State has laws about transportation network companies, which are usually called like rideshare companies or rideshare drivers. And Seattle laws are only about other apps. They're not about rideshare apps. So what we talk about today and what the Office of Labor Standards can do doesn't apply to Uber and Lyft, but it would apply to UberEats and other apps like Grubhub and DoorDash. And the reason for that is just that the state law says that the state is the only entity that can regulate those rideshare companies. So that's why Seattle has separate laws for the other apps. But if you need help with anything related to rideshare, then I would check out Labor and Industries, Washington State. Okay, now we are going to move on to the content of the training, and we'll start by hearing from Lucas, an UberEats driver who was experiencing some issues with his pay, reached out to OLS, and got us started down the path of investigation and ultimately this settlement.
OLS has been an amazing partner to work with throughout this process. So I wanted to speak a little bit about my background and then also share my screen if that's okay. I know we communicated about that, Meredith.
Yes, you should be able to share. Let
Okay.
me know if it doesn't work because I can share your documents as well.
Okay, cool. It looks like it works. I will do that in a moment. So my background, I was a former tech contractor back in 2001, kind of during the pandemic, and I got sick. I got really sick with COVID and eventually got laid off because I just couldn't show up for work because I was just literally long COVID, sick for months and months. I did eventually get better, but I was unemployed, wanted to make some money, wanted to get out of the apartment, actually move around. So I figured, hey, doing some of the this gig work, riding my bike, Uber Eats, DoorDash sounds like something I should try out. So I did that. I liked it, and I was doing that for about a year or so when I started noticing this boost promotion coming up on the map and was just trying to make sense of the numbers, and the math wasn't mathing. So I dug into it. I started taking screenshots and then somehow learned about OLS, probably just looked you guys up and sent an email, or I think maybe you have some system, hopefully sharing the right screen. I hope you don't mind, Claire. I think you're on the call. I'm sharing the email that we initially had back in, gosh, 2023 now. Um, so we went back and forth, Claire and I, just uh, she thought there might have been something here and asked that I send more documentation. And I was like, sure, hold my beer. I got you. So I put together a bunch of screenshots and a couple of documents just all in Google Drive and shared it with OLS and laid it out kind of as best as I could as in the most compelling way as I thought I could. And that kind of looks like this. This is really Sorry, this is really zoomed in, so that was throwing me off. So basically, I just wanted to show what a screenshot of like a trip detail looked like on the payment side. I figured OLS probably had familiarity with this, but I know you all work with a lot of different things, so maybe not. So just highlighting in here, okay, the time that I got uh, an order, what the boost amount was actually looking like. As you can see, just a few pennies here, so not particularly satisfying, and then highlighting, okay, this is a boost zone. This is what the map looks like for me. This is me inside of the map. And then obviously you can see this multiplier is like almost three. It's 2.7x. And then again, highlighting the time that I was supposed to be receiving this. And then this was kind of smoking gun in my mind, where I was like, okay, how is this boost promotion actually working? Let me find out the definition on Uber Eats' website. And they lay it out, pretty clearly here that we put these promotions out so you can earn more money per trip, and it works basically as you'd expect. You see a number on the screen. If it's, if your normal amount of earnings for that trip is $10 and your boost multiplier is 2x, then you should be earning 20. That all seems about right to me, how this should work, but obviously those numbers not really working when you can see, importantly, this is on base fare. My base fare is $2.81. I'm getting 19 cents, so this is like a 1.1x according to the definition that you're giving. So that's kind of what led this all off. I also went in and had some chats with Uber support and kind of laid this out to them like, hey, can you explain to me what is going on with this? Like, can you look into this and tell me if I have this base fare and I have this boost multiplier, what my amount should be for total payout? And again, smoking guns, it's like you're telling me my understanding of how this should work, but obviously that this is not what I'm getting. So that all led to a whole bunch of screenshots. I don't think I need to go into all of them, but you can see just like endless screenshots of all of these different promotions over time. This algorithm just seemed to just really get away from Uber. I just feel like kind of knowing how these things work a bit on the tech side, I don't think there was a lot of human oversight. Like towards the end there, it's getting up close to like 4x. Like this is 3.4 here. I've seen some that were like 3.7, 3.9 maybe. Anyways, so that was getting just kind of wild. I also just showed the schedule, trying to prove like, okay, you're showing these a week out in advance and just trying to line these up with the dates. And then some trips specifically of like what I showed initially, just a lot more examples of what I was making per trip. There are some very sad boosts in here that are just a few pennies. Yeah, here's a 34-cent one. I even well, and then I had the chats. I know there's one in here that shows a whole bunch of chats with the support people. I even calculated out all of the underpay that I was expecting per week, and as you can see, this is adding up into like the thousands over the course of several months. So it felt to me like if this is real, like if I'm understanding this correctly, it seems like there should be something here. And this definition that Uber's putting out just isn't, it's just not making sense. And so obviously OLS felt the same way, and they were able to make things happen. And 2 years later, we got our successful settlement here. So yeah, I think the kind of takeaway from my story is basically if you see something, not only should you say something, you should like also document what you're observing, and 2025, we all have phones. It's easy to take pictures and screenshots. Just go ahead and do that, and you can organize these things nicely in a thing like Google Drive or whatever. So yeah, that's basically my story. Hopefully, hopefully, that's helpful.
Yeah, that was great, Lucas. It was really cool to see how you documented everything, so many screenshots. I could see, yeah, just so many screenshots doing your own calculations and saying like, hey, I found the policy. It's pretty clear that it says on this Uber page that you're supposed to pay the boost amount. Um, Claire, I wonder if you have anything to add about kind of what you saw and then what you did after getting this email from Lucas, if you're willing to talk about it.
Yeah. Well, definitely echo the note about documentation. I think just Lucas having taken the time to collect all of that evidence just made it so much easier on our end to be able to um, understand better what was going on, and then for me to kind of be able to make a case to the people who make decisions about what we take on and what we don't about how important this was. I think in some ways that at first some people were seeing it as like, well, this is like a little technical issue, like there's something wrong with their algorithm. And I think the part that I have always felt was really important was just um, the lack of transparency. I think, when this complaint came in, the app-based worker minimum payment law wasn't in effect yet. We were just looking at it through the lens of the Independent Contractor Protections Ordinance. And so much of that law is about giving transparent information to contractors so they can make informed decisions about what work they want to take on and what they don't. So to tell someone, hey, if you work at this time in this place, you'll make 5 times as much as you would otherwise, it's a little bit of an exaggeration. It's just not allowing people to make those choices. I just thought like, what if someone would have been at home having dinner with their family, but they thought, oh, I have to work right this minute and I'm going to make 4 times as much. And that's really going to be worthwhile. And then at the end, they're really making like 20 extra cents. So after Lucas sent all that documentation to us, I, with support from my colleague Mark, put together a letter that we sent to UberEats, and they got back to us basically saying it was Lucas's misunderstanding of the program, but that they would settle the amount that we were asking for just as like a gesture of like their understanding of the inconvenience or something like that, which I think at that point we were like, okay, there's got to be something going on here because companies don't usually just do that for no reason. And they kind of gave us an accounting of how they were actually calculating the bonus allegedly, which was a completely undisclosed per mile rate of something like, I won't say the number because I don't remember, but it was like, oh, we're actually multiplying this mileage rate, which was something like 10 cents per mile times the multiplier. And you're like, okay, because that is not stated anywhere. One of the helpful things that Lucas did was take this to UberEats support multiple times. So then we had all these conversations with the support technicians who were not able to explain the boost promotion any better than it was in the app, and in fact, like reinforced what the plain language interpretation was that was advertised to drivers. So yeah, I'm really appreciative of Lucas's participation. Definitely set us up for success here. It was a long-term project, but I just really think it was important to try to hold this company accountable to the way it was essentially manipulating workers to do what was most beneficial to them rather than what was actually necessarily beneficial to the worker in their decision and in how to take on times and deliveries. But yeah, thank you.
Thank you, Claire. Yeah, absolutely. It's just good to see how it all came together.
Before we move on, I'm just curious, like Sarah with the folks in the room there, or if Werke, and Connie, folks with the partners, is this an issue you're also seeing from folks? Have you all seen this boost come up as you're on the apps? Like Werke, I know you do driving, and so yeah, I'm just curious if other folks have also been seeing this.
So yeah, Hi, Colleen. Yeah, I was asking the team, and some of them they say, but some of them still no. They was having earlier question, but no, right now.
Okay.
All right.
And we'll have more time for questions at the end too, so we can definitely make sure to answer that, Sarah.
Sounds good. All right, thanks.
And then I do want to point out that Blair said in the chat that they discontinued the Boost program soon after the initial complaint. So that's information to have.
Well, hopefully you're not continuing to see it happen. And if you are, you could let us know.
Yeah. And that's one of the reasons I put together this slide, is because a lot of the press that came out around this settlement was talking about how, oh, that, you know, there are violations of the app-based worker laws, which is true, but also the biggest section of this settlement was not a violation of Seattle's app-based worker laws. It was a violation of the independent contractor protections, like Claire was saying, because if a hiring entity or a business promises to pay somebody something and then they don't do that, that's a violation of our independent contractor protections, and it's just like a broken promise, which is different than kind of all the other things that our app-based worker laws require. So yeah, Lucas did an excellent job. Here's a slide that I made, very similar, but so I don't need to go over it. But yeah, I mean, part of what came up for us is that, like, oh, app-based workers, you know, if they're considered independent contractors, then they get the protections of the independent contractor law. And a lot of common issues for independent contractors are similar to what they were in this situation: not being paid a promised amount, no contract or no written description of the work, which is not necessarily an issue here, but not a very clear description of the work, or at least a description that did not match up with what ended up being paid. And then contractors also experience a lot of the time not being paid on time or not being paid at all for the work that they do. So those are some of the main issues that we see for independent contractors. And I would ask folks either come off mute or in the chat, have you ever experienced issues independent contracting or doing app-based work? Don't have to be like this issue, could be something else, but curious about folks' experiences. And if you yourself don't work as a contractor or an app-based worker, but you know people who do, or you've had experiences talking to workers who have had issues, you're also welcome to share those. And then I have a question from Lane in the chat, which maybe is probably good to ask while Claire and Lucas are still here. Yeah, were conversations with Uber, like, were any of those phone conversations, were they just text? And then if they were phone conversations, how were those recorded? I don't know if Claire or Lucas, either of you have an answer to that.
Are we speaking to the support conversations or the actual conversations with corporate on the details of the litigation?
Oh, I meant the support conversations.
Okay.
Yeah.
Oh, so
This
those.
helped. Go ahead.
Yeah, thanks for clarifying. So for the support, it would usually start out with chat. It's like a lot of the help services that you get from big tech. You have options basically if you want to do it as a chat or a phone call, or sometimes it starts as a chat and turns into a phone call. So obviously the chats can be documented, although I do recall those expire after a certain amount of time, which was frustrating. That was part of the reason that I just have thousands of screenshots of all of the app is, you know, in my photo albums. But yeah, everything expires after a certain amount of time. So that was the only documentation. I mean, I'm sure they're recording the conversations on their end, but I never recorded any of the conversations. I do believe that was something that Claire may have asked at some point, but I don't, if I did it, I don't think I ever shared it.
Thanks, Lucas. Well, in the interest of time, if nobody wants to share an issue, totally fine. And I have another question for you. I'm going to make somebody participate somehow. What are examples folks know of that are like that is independent contractor work. Besides app-based work, that's a good example. But if folks have other examples about what types of work count as independent contractor work, or what kind of work you've seen independent contractors do, would love to hear. Either come off mute or in the chat. And I can give a couple. So Nichelle says in the chat, lots of people who are independent artists, DJs, and performers. Yeah, that's a great example. House cleaners and nannies. Thank you, Colleen. And I will say most types of work can be, you can be employed, an employee, or an independent contractor. But oh yeah, tech world, lots of independent contractors, landscapers, and then when we think of contractors like construction, also have a lot of independent contractors. Thank you all for hairstylists. Yeah, thanks, Connie. Thank you for humoring me, everyone. So, interpreters, Claire's right. So whatever type of work independent contractors do, like the industry, doesn't matter. We have an independent contractors ordinance that covers specific independent contractors regardless of the type of work that they do. So in order to be covered by Seattle's independent contractor protections ordinance, contractors have to be self-employed. So they're a single person independent contractor. That means that they don't have employees. So people who have employees would not be protected by this law. They have to be doing work, or you have to be doing work for a commercial hiring entity. A commercial hiring entity could be a for-profit or nonprofit business, but it's not like an individual person or a private household. So in the domestic work world, this comes up a lot because domestic workers might be independent contractors, but if they're doing work for a private household, this particular law doesn't protect them. We have a domestic workers ordinance that would protect folks otherwise. But that's kind of a confusing area. One example I like to give is if you're a photographer and you are taking photographs at somebody's wedding, but your contract is just with like the couple who's getting married, that's probably not covered because they're not running a business. But if you have a contract with a wedding planner, that person is running a business. And so that relationship would be protected by this ordinance. Okay, so you're a self-employed, single person, no employees, you're doing work for a commercial hiring entity, you would perform all or part of the work in Seattle in order to be covered by this Seattle ordinance, and the hiring entity should know that you're doing the work in Seattle. If they have no reason to know that you're doing the work in Seattle, it gets more complicated. And then the last bit is just this ordinance kicks in when you expect that you'll be paid at least $600 in a calendar year working for this particular hiring entity. It doesn't have to be $600 all in one go. It's just like, hey, I might do multiple projects for this hiring entity that will add up to more than $600 over the calendar year. So that's the last one. And then basic protections. So like Claire was saying, part of the reason that we have this ordinance is because contractors should know what kind of work they're agreeing to before they start doing the work. They should know how much they're going to be paid before they start doing the work, and then they should be paid on time. So that's a lot of what the basic protections are. We have something called a pre-work written notice that's required. That just means that the hiring entities are supposed to give you information about the work before you've agreed to do it for them. And so that might be, that's like, who is the hiring entity? Where are they located? How much are they going to pay you? What is the pay basis? Is it hourly? Is it per project? Are there tips involved? That might be like for caterers or bartenders, there might be tips involved. And so all of that should be outlined before any of the work happens. And it should be in writing instead of in a phone call. So that's one thing hiring entities have to do. One of the biggest ones is timely payment. So that's payment within 30 days of the work being complete or on a date that you and the hiring entity agree on. So it doesn't have to be 30 days, but it should be written down when they're going to pay you. And then when they pay you, they should be giving you an itemized payment notice, kind of like a pay stub, but not, because you're not being paid as an employee, but something that just is like, here's the breakdown. Here's your pay basis again, like, is it hourly? Here's how many hours you worked. Here's the rate. We're paying you like $250 per hour or $25 per hour. And then, like, are there any deductions that we agreed on for, like, we bought this thing for you, so we're going to deduct that out of your pay, or we need to reimburse you for something that you bought to do this work. All of that should be outlined in the itemized payment notice. And so that's one of the other protections that are available to independent contractors. And then what we just talked about this time is there are specific independent contractor issues for app-based workers, like incentives. Even though the Boost program doesn't exist in Seattle anymore, there are other apps that use incentives. So is the company paying you what they promised? I think that's something that comes up a lot. Like, are you being paid what was promised, what you agreed to when you accepted the offer? That's a specific issue for independent contractors who are working as app-based workers. All right. Turn it over to Colleen.
Great. So with that, we'll talk a little bit about, okay, thank you, Lucas. Thanks for being here and sharing. So now we'll get on into the portion talking a little bit more about the app-based worker protections. And I'll just say we're going to be pretty lightly covering these. So there's more details, but we'll put some of the links in the chat so folks can read more in depth about some of them. So who can name for me, put it in the chat, what is a protection for app-based workers? If you can think of one that you've heard about or that you've talked to workers about, if anyone has any idea. And if not, then you're in the right place, because we're going to talk. I'll give a moment. Okay, great. Connie, I see paid sick and safe time, minimum pay. Awesome. Yes. So we'll go to the next slide. So those are two of them. We have minimum pay for time and mileage, the right to earn and use paid sick and safe time, and then also protections from deactivation. So I'll go in more in depth to each of these. And first, let's look at who's covered. So the minimum pay and paid sick time laws apply to folks when you're working for apps that set the rate of pay or monitor your mileage and spend time and time spent working. So examples of these are like UberEats, Instacart, DoorDash, the ones that are tracking the mileage and setting the rate of pay. The deactivation law applies to more app-based workers, and it includes workers who set their own rates and when the app companies aren't monitoring for mileage and time. So an example of this could be TaskRabbit, where there's a little bit more, there's some differences, right, between that app and some of these other apps. And the minimum payment for 2025, these are the rates. And again, this is just kind of the brief overview. So I'm going to drop in here our fact sheet as well that can give more details about this. But the minimum pay will be either $5.20 per offer or 45 cents a minute plus 70 cents per mile. And in order to figure out what time and miles count toward that, there's a great chart on the link I just put in the chat that can show you a bit more detail about it. But it basically depends on if you start work for the offer inside or outside of Seattle. So you can see on there some more of that description. But these are the numbers that you'll pay attention to when you're looking at minimum payment. All right, then the paid sick and safe time covered workers will earn 1 day of paid sick and safe time for every 30 days where they have at least one stop for work in Seattle. And if you've worked in Seattle at least once in the past 90 days, you can take 24 hours of paid sick and safe time off at a time. And just a reminder that you can use paid sick and safe time to care for yourself or for a family member. And it can be for when you're sick or also for preventative care if you need to go to the doctor or take someone to the doctor, as well as the safe time portion is for situations of domestic violence, sexual assault, stalking, and those are some of the uses that you can take for this day. And you don't need to provide a doctor's note unless you're gone for 3 consecutive days. And yes, Meredith, were you going to say something?
I was just going to add, safe time also applies for when schools or places of care are closed. So school or daycare is closed. Maybe there's a snow day or something happened. Or daycare is sometimes closed when kids are sick, and so if people have to stay home for those reasons. And yeah, Colleen just dropped some helpful information about paid sick and safe time protection.
Great, thank you. Great, and then our last one is protections for deactivation. We know this is a huge issue and has come up a lot for folks. So this law basically talks about how a company can only deactivate you for certain reasons, and there are some reasons that are not allowed. Companies should be deactivated and give you evidence that they look at when they are deciding to deactivate you, and you should also be given a chance to appeal any deactivation. So those are, again, kind of the basic high-level points around deactivation, but I'll drop more information about that one as well. And I will pass back to Meredith so that we can talk about more, what can we do if we see these issues coming up or we hear folks talking about them in the community, how can we support workers with it?
Yeah, so we know that we have labor ordinances, but that doesn't mean that businesses always follow them. And so what can workers do if the business is not following these laws? And I'll say that's also true if they're not following these laws or if workers experience retaliation, which is like punishment basically for trying to speak up about their rights, or for trying to enforce their rights. So if workers talk to a company, talk to other workers, talk to us, talk to the press about their rights, and then the company does something to them and it impacts them negatively, that would be retaliation. And that's also one of the things that you can come to OLS about. So yeah, what happens if folks violate the law? You can get support from OLS. So people can file a complaint, or workers can file a complaint, or even just ask a question. Both are fine. Like people will answer your questions, even if you do not want to pursue the complaint further. To do that, you can call or go online. We have a complaint form. If you ask, we will do our best to keep your information private. But we might contact the hiring entity about the issue, and depending on the situation, it's hard to do that if we can't use your name. So that's just something to consider, especially if we're like, this worker has a problem, but we are not going to tell you who it is. That might not work out so well. So there's some considerations in terms of keeping that information private. So yeah, a lot of times, even if we don't open an investigation, we will contact the hiring entity or the business and say, hey, you need to fix this. Depending on our capacity and what the case looks like, OLS can also open an investigation and try to resolve the issue that way, which is a little, or is more time consuming. I think like Lucas was saying, he contacted Claire back in 2023. This UberEats case didn't settle until earlier this year, so it can be time consuming to investigate. But part of that is just there's might be a lot of people involved. There might be a lot of information that folks need to work through or look through, a lot of people on the business side to talk to, a lot of workers to talk to. And so that's part of why investigations can take a long time, but you can get the information and we will reach out to the hiring entity, even if we are not going to end up investigating. And then yes, these are the ways that folks can contact us. We have our website, phone, as Colleen was saying earlier. We have interpretation available for people to call in. Somebody might answer in English, but then we can have access to language line to have interpretation over the phone. If people want to come into the office, they are welcome to do that. We have investigators who are ready to take walk-ins and talk to people who just come to our office. If we're doing interpretation that way, we might use language line, or if we know ahead of time, we can sometimes get an in-person interpreter. Yeah, so the 2 links on the page, which I think we can send out this PowerPoint to everybody in attendance after the fact, but these go to our employee or worker inquiry. We renamed it. And then the email for business or employers inquiry is also on there. So that's more for businesses. We support both workers and businesses. We want businesses to comply. The laws are confusing, so sometimes they need help understanding them. And so we will answer anybody's question, whether they're a worker or a business.